Hello students. Today we are going to start new unit on Indian Constitution and human rights. Today's discussion will be focused on salient features of Indian Constitution. The Constitution of India is a unique document that reflects the vision of justice, liberty, equality and fraternity. It is the lengthiest written constitution in the world, adopted in 1949 and enforced on 26 January 1950. Originally, it contained a preamble, 395 articles, divided into 22 parts and 8 schedules. As of 2019, it consists of about 470 articles, divided into 25 parts and 12 schedules. Its vastness results from India's diversity, geographical size, and the need to incorporate detailed administrative, political, and social provisions. The influence of the Government of India Act 1935 and the presence of eminent legal experts like Dr. B.R. Ambedkar in the Constituent Assembly contributed to its comprehensiveness. Unlike brief constitutions like that of United States, which are largely unwritten, the Indian Constitution covers every aspect of governance, from the structure of government to the rights and duties of citizens, making it both exhaustive and functional for a diverse nation. The Constitution of India is an extraordinary blend of ideas drawn from various world constitutions and, rather, I should say, but adapted to India's conditions. The framers studied the working of several democratic systems to create a balanced and original framework. From the Government of India Act 1935, India inherited the federal scheme, Office of Governor, Public Service Commissions, emergency provisions, and administrative details. From the British Constitution came parliamentary government, rule of law, single citizenship, bicameralism, and the cabinet system, ensuring collective responsibility. The US Constitution inspired the fundamental rights, independence of the judiciary, judicial review, and the post of vice president. From the Irish Constitution, India borrowed the directive principles of state policy, the method of electing the president, and nomination of members to the Rajya Sabha. The Canadian model contributed federalism with a strong center and advisory jurisdiction of the Supreme Court, while Australia provided the concurrent list and joint sitting of Parliament. From Weimar Germany came the provisions to suspend fundamental rights during an emergency. France gave us the republican ideal and the principles of liberty, equality, and fraternity in the preamble. The Soviet Union contributed the ideals of justice and fundamental duties. South Africa influenced the procedure for constitutional amendments and election of Rajya Sabha members, and the Japanese constitution inspired the idea of procedure established by law. Thus, India's constitution is not a copy or not a bag of borrowings, but a creative synthesis uniting global wisdom with Indian democratic philosophy. The Constitution of India is known as the world's longest and most detailed written constitution. When it was adopted, it had only, in 1949, it had only 395 articles, 22 parts, and 8 schedules. Over time, with several amendments, as of 2019, it has grown to about 470 articles and 12 schedules. Now, why is it so long and detailed? There are few important reasons. First, India is a very large and diverse country with many religions, language, and tradition. So the constitution had to include detailed provisions to suit this diversity. Second, the framers borrowed many ideas from earlier laws, especially the Government of India Act of 1935. which provided a detailed administrative framework. Third, unlike in countries like US, India needed one single constitution for both the center and the states because we follow a federal system with a strong central government. Finally, the Constituent Assembly included many legal experts like Dr. B.R. Ambedkar, K.M. Munshi, and Aladi Krishnaswamy Iyer, who preferred writing clear and specific rules to avoid confusion in the future. Moreover, large number of or the majority of Indian population was still illiterate and not familiar with the nitty-gritties of the constitution or parliamentary democracy that we had adopted or borrowed from West. And therefore, in order to prevent the elite becoming autocrat, it was necessary that all the provisions and safeguards should be very broadly explained and in detail it should be mentioned so that there are enough checks and balances on legislative, executive, and judicial power on the one hand, and enough checks and balances on the federal central authority and the state authority so that there are no clashes between the not only between the different organs of the government but also the different sets of government that we were having at the center and the state. There were areas of clash, overlapping, etc., etc., which had to be clearly delineated, defined, but over a period of time, there were going to be many, many issues that we may call as the gray areas, for which judiciary was given the power of reviewing any act or any statute in the light of the constitution to keep each organ or each set of government within its purview and protect the liberty of the people, which is the ultimate purpose of our constitution. The Constitution of India strikes a delicate balance between rigidity and flexibility, ensuring stability while allowing adaptation. Article 368 provides the framework for constitutional amendments. Some provisions, such as those related to citizenship or state boundaries, can be changed by a simple majority in parliament. Others, like fundamental rights or the federal division of powers, require a special majority, two-thirds of members present and voting, and a majority of total membership. In certain cases, like the election of the president or distribution of legislative powers, amendments need ratification by at least half of the state legislatures. This ensures uh, that essential principles remain secure, yet the constitution evolves with time. India has successfully amended its constitution for reform without losing continuity. Hence, it is neither rigid like the US constitution nor overly flexible like the British model. The constitution establishes a federal system, but one with a distinct unitary tilt. It includes dual governments, center and state, divisions of power, supremacy of the constitution, and an independent judiciary. However, the center holds greater authority in legislative, financial, and emergency matters. Article 1 declares India India a union of states. Rather, I should say India, that is Bharat, is a union of states, emphasizing that the federation is not formed by agreement amongst the states and no state has the right to secede. Features such as a single citizenship, integrated judiciary, appointment of governors by the center, all India services. Features such as single citizenship, integrated judiciary, appointment of governors by the center, and all India services strengthen national unity. During emergencies under Article 352, 356, and 360, India operates as a unitary state to protect integrity and security. Scholars describe it variously as quasi federal, K.C. Vere used the term quasi-federal to describe India's constitution as federal in form but unitary in spirit. This means that while our constitution looks federal with powers divided between center and states, in practice it gives greater power to the center. The purpose is to make center more strong, to maintain unity and strength in a diverse country like India. Cooperative federalism, as called by Granville Aston, and federal in form but unitary in spirit. Thus, India's federalism balances regional autonomy with national cohesion. India follows the British model of parliamentary democracy, ensuring accountability of the executive to the legislature. Though we have never or nowhere used the term parliamentary democracy in our constitution, but the structure, the functioning, and the accountability of the legislature, of the executive to the legislature, indicates that yes, we have opted for parliamentary democracy. The purpose was to ensure accountability of the executive to the legislature. This system functions both at the center and in the states. Key features include the presence of nominal and real executives, collective responsibility of the councils, of collective responsibility of the council of ministers to parliament, and majority party rule. The prime minister and chief minister lead their respective governments, embodying political leadership within our constitutional framework. Articles 74 and 75 define the relationship between the president and the council of ministers, while Article 164 extends a similar provision to the states. Unlike the British system, where parliament is sovereign, India's parliament operates within constitutional limits. We were having before us an extremely strong parliament of Britain, for which it was often said that British parliament can do everything except making man a woman and woman a man. This reflects the strength or absolute power or absolute superiority of the parliament in British political system. Since we were an immature democracy, we were an infant democracy. People were largely illiterate. People were not well versed in the practices of democracy. Therefore, leaving parliament to such kind of a strength was not wise enough. And therefore, what we made supreme is the constitution, not the parliament. So, parliament operates within constitutional limits. Moreover, India is a republic with an elected head of the state, unlike Britain's hereditary monarchy. This parliamentary structure ensures a responsible government while preserving democratic participation and legislative oversight. The Indian Constitution harmonizes British parliamentary sovereignty with American judicial supremacy. We were having examples of two extreme cases. In Britain, Parliament was so strong that it can do anything except to make man a woman and woman a man. On the one side, we were having this kind of example of parliamentary sovereignty. On the other hand, we were having a strong judicial supremacy or strong judicial review power of American judiciary, because of which it was often said that American constitution is a judges made constitution. Constitution is what the judges say in America. And therefore, we found a midway between the two, the midway between parliamentary sovereignty and American judicial supremacy. While Parliament can legislate extensively and amend the Constitution under Article 368, the Supreme Court safeguards constitutional supremacy through judicial review. This balance ensures that neither body can act arbitrarily. The doctrine of judicial review empowers the court to strike down unconstitutional laws, while Parliament can respond through corrective amendments subject to the basic structural limitation established in the Keshwanand Bharti case, 1973. One more thing that needs to be mentioned here is that again we did not use the term judicial review anywhere in the Constitution. It is only in the context of fundamental right within Article 13, the judiciary has been given the power to review any act or statute of the parliament or the decision of the executive in the light of the constitution and declare it null and void if it is in abrogation of the constitution. So, by not using, we were careful enough not to use the term judicial review. Otherwise, that might have given extensive power to the judiciary. So, judicial autocracy is as bad as parliamentary autocracy. Now, since we bound our parliament also through judicial developments like basic structure theory, given in the Keshwan and Bharti case. Constitution's use of procedure established by law in Article 21 instead of America's due process further balances individual liberty with legislative authority. Initially. Later on, uh, of course, since 1978 onwards, we incorporated due process also. This synthesis has made India's democracy resilient, preventing both parliamentary dictatorship and judicial overreach, while ensuring the supremacy of the constitution over all institutions. India's judiciary is both integrated and independent. Unlike the US, where separate federal and state courts exist, India has a single unified judicial system. We have a pyramid like structure. The Supreme Court stands at the apex, followed by high courts at the state level and subordinate courts below them. Article 124 to 147 define the composition, powers, and independence of the Supreme Court. Judges enjoy security of tenure, fixed service conditions, and removal only through impeachment by parliament, which is a very tough procedure, not an easy one. But nevertheless, judges are not um, beyond any kind of judicial scrutiny. The judiciary safeguards fundamental rights from Article 12 to 35, mentioned through Article 12 to 35, and acts as the guardian of the Constitution. Its independence is ensured by separation of powers and non interference from the executive. As the final interpreter of the Constitution, the Supreme Court protects the rule of law, ensuring justice and maintaining the balance between the center and the states. Part 3 of the Constitution, that runs from Article 12 to 35, guarantees six categories of fundamental rights to citizens. These include right to equality, right to freedom, the right against exploitation, the right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. Dr. Ambedkar described Article 32 as the heart and soul of the Constitution, empowering citizens to approach the Supreme Court for protection of their rights. These rights reflect liberal democratic ideals and are enforceable by the judiciary. They embody the principles that they embody the principle that every individual possesses inherent dignity and no authority, public or private, can violate it. Together, these provisions form the foundation of India's constitutional democracy. The directive principles of state policy, enshrined in Part 4 from Article 36 to 51, guide the state in establishing a welfare society. Dr. B.R. Ambedkar termed them as novel feature of the Constitution. Influenced by the Irish Constitution, they aim to realize social and economic democracy through state policies. The directives can be categorized as socialist, Gandhian, and of course, liberal intellectual. They include provisions for reducing inequality, ensuring fair distribution of wealth, promoting education, and protecting the environment. Though non justiciable, Article 37 declares them fundamental to governance, and over time, we will see later on, how the courts have harmonized fundamental rights and directive principles and declared them symbiotic and mutually reciprocal to each other to ensure that liberty and welfare progress together. We have the example of cases like Minerva Mills versus Union of India of 1980, wherein the court said very clearly that fundamental rights and directive principles of state policies are not contradictory, but they are complementary to each other. Thus, directive principles provide the moral and social foundations for a just and equitable state. Fundamental rights are incomplete unless we associate them with duties. As discussed earlier, rights and duties are are the two sides of the same coin, and therefore, our chapter on fundamental rights is incomplete without a reference to equivalent fundamental duties. Fundamental duties, though were not in the initial constitution, they were added by the 42nd Amendment in 1976 based on the recommendations of the Swarnit Singh Committee. Later, the 86th Amendment in 2002 added one more duty related to education. Article 51A, placed in Part 4A, lists 11 duties reminding citizens of their obligations to the nation, society, and the environment. These include respecting the Constitution, promoting harmony, safeguarding public property, and protecting India's unity. Though non justiciable, they serve as moral obligations complementing fundamental rights inspired by the Soviet model. They emphasized that citizenship entails both privileges and responsibilities. The inclusion of these duties ensure that the Constitution nurtures civic discipline, moral awareness, and patriotic commitment among citizens, thus maintaining a balance between individual rights and his duties as well as his duties as an individual as well as in collective situation. The Constitution of India firmly establishes a secular state. It does not recognize any official religion, state religion, and ensures equal respect for all faiths. So, we are not a theocratic state. We are a state that does not have any official state religion like Britain. Secularism here is positive. It stands for the protection of all religions rather than their exclusion from the public sphere. Article 25 to 28 guarantees freedom of conscience and the right to freely profess, practice, and propagate religion. Article 30 safeguards the rights of minorities. Article 29 and 30 safeguards the rights of minorities to establish and administer educational institutions. The word secular was formally added to the preamble by the 42nd Amendment of 1976. Although the spirit existed from the beginning, when India became independent, with theocratic states surrounding it, Islamic State of Pakistan on east and west, Hindu Nepal on north, and largely a Buddhist Sri Lanka. India, with more than 80% of Hindu population, preferred not to have any state religion. Though the roots of Sanatan can be seen or are clearly reflected in our constitution. Indian secularism, if we talk about, is completely different from the Western secularism. Its fundamental pillars are tolerance, equality, and mutual respect for each other. Indian secularism acknowledges tolerance and pluralism or advocates tolerance and pluralism. Inspired by leaders inspired by visionaries, the father of the constitution, uh, who saw faith as a personal matter but equality as a collective duty. It ensures unity amidst diversity and harmony among communities. The Constitution grants universal adult franchise, making democracy truly inclusive. Article 326 provides that every citizen aged 18 or above can vote in Lok Sabha and state assembly elections without any kind of discrimination on the basis of caste, creed, sex, and religion or wealth. The 61st Amendment Act of 1988 reduced the voting age from 21 to 18. This principle ensures political equality and empowers citizens to shape their government. The Constitution also establishes single citizenship for all Indians. Regardless of the state of origin, all citizens enjoy equal civil and political rights across the nation. This feature, borrowed from the British system, strengthens national integration and equality. By combining universal suffrage with single citizenship, the Constitution unites India politically and socially under one democratic identity. The Constitution establishes several independent bodies to maintain the democratic framework. The Election Commission, Article 324 to 329, deals with it, ensures free and fair elections at all levels. The Comptroller and Auditor General audits government accounts, promoting financial accountability. The Union and State Public Service Commissions conduct recruitment for civil services and advise the government on disciplinary matters. These institutions function autonomously to prevent executive interference. Their independence is safeguarded through fixed tenure, secure salaries, and constitutional status. Together, they uphold the principles of transparency, efficiency, and impartiality that define India's democratic governance. The Constitution empowers the President to deal with extraordinary situations through emergency provisions. The national emergency under Article 352 may be proclaimed during war, external aggression, or armed rebellion. Article 356 allows president's rule in a state for failure of constitutional machinery, while Article 360 provides for financial emergency that we never had till the date in India. These provisions protect unity, integrity, and sovereignty. Further, the 73rd and 74th Amendments, brought about in 1992, added a third tier of government, that is, panchayats and municipalities. This decentralized governance ensures grassroots democracy and participatory development. Later, the 97th Amendment, that was brought in 2011, granted constitutional recognition to cooperative societies, strengthening local self government and collective economic action. The Constitution of India remains a living, adaptable, and visionary document. Its blend of rigidity and flexibility, federalism with unitary bias, and the balance between rights and duties ensure democratic stability. It reflects India's historical experience, philosophical depth, and social realities. Despite criticism of being lengthy or borrowed, the framers crafted a framework suited to Indian diversity and aspiration, and also keeping in mind the infancy of democracy in our country. By incorporating global ideas and indigenous wisdom, the Constitution continues to guide the world's largest democracy towards justice, equality, and human dignity. It stands as both a legal code and a moral covenant, symbolizing India's enduring faith in constitutionalism and democratic governance. Thank you.